We will go on the record in the matter 25 CF 27, State of Wisconsin versus James Langer. The state appears through Assistant District Attorney Jose Ard in person. We have Daniel Chapman, Defense Counsel, in person. We also have Mr. Langer in person in custody. We're set today in this matter for a sentencing portion of this case. Mr. Langer pled guilty to count 3, possession with intent.
And there it is, the guilty plea. Notice the modifier, on or near a youth center. That's huge. In Wisconsin, drug crimes near schools or youth centers carry sentence enhancers. Translation: the punishment just got a whole lot heavier. Already, this isn't a run-of-the-mill possession. Case it's possession with intent to deal, in a zone where kids are supposed to be safe.
Intent amphetamine, methamphetamine, greater than 10 grams, but less than 50 grams. On or near a youth center. So with that modifier, he pled guilty on June 4th, 2025. The court ordered a pre-sentence investigation report. The court has reviewed the report, and out of my review, I do not believe anything jumped out at this court as a material issue that needs to be addressed on the record. Mr. Ard, did you receive a copy of the PSI?
Yes, Your Honor, I did.
And you reviewed that?
Yes, Your Honor.
Any corrections or modifications of the material nature that should be stated on the record?
Your Honor, the only correction I would note is that in the breakdown of the prior record for Mr. Langer, of the offense date of May 16, 2007, there seems to be some confusion about the offenses that were actually listed. It looks like count 1 was actually aiding and abetting possessing chemical agents with intent to manufacture meth. Count 2 was causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to meth.
I'm just going to ask you to slow
My
down.
bad. Count 2 was causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to meth. Count 3 was terroristic threats. Of those 3 counts, he was convicted of count 2, Your Honor.
All right. Okay. Other than that, no material.
Hold up, did you catch that? A prior conviction for allowing a child to be exposed to meth. That's not just reckless, it's chilling. Judges absolutely take note of priors involving kids because it goes directly to risk and dangerousness. You can already feel the sentencing scale tilting hard against him.
Corrections or modifications?
No, Your Honor.
And while Mr. Chapman is talking with Mr. Langer,
what was count 2 again that he was convicted of?
The causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to methamphetamine.
all right, Mr. Ard.
Okay.
I don't know if you, I can't recall if you argued something of this degree in front of the court. I just want to remind you to slow down.
Understood, Your Honor.
So that the court reporter can take everything down accurately. Mr. Chapman, did you receive a copy of the PSI?
I did, Your Honor.
And you reviewed it thoroughly?
Yes, I did.
And you did so with Mr. Langer?
Yes.
Did you have any material corrections or modifications for the record?
The only thing that Mr. Langer wanted to note is that he recalls his treatment history differently. The agent says that in 2022, he was referred to follow-up outpatient treatment at North Star Regional. He recalls North Star Regional being only an inpatient treatment facility. He does not recall any outpatient after that. I'm sure the agent had records that she was looking at, but Mr. Langer's recollection differs.
Okay, thank you. Mr. Ard, I will now turn to you for your argument and sentencing recommendation, please.
Thank you, Your Honor. The DOC currently recommends 7.5 to 9 years initial confinement and 3 to 4 years extended supervision. The state's recommendation will be for 9 years total, broken down as 6 years initial confinement, 3 years extended supervision, eligible for programming after 3 years of initial confinement.
Can you repeat that? You went a little fast and
Nope,
I'm not used
sorry
to it
about
being
that.
spit out right away.
Understood. So once more, the DOC recommends 7.5 to 9 years initial
9.5
confinement.
actually.
Oh, my apologies. And 3 to 4 years extended supervision. The state's recommendation will be for 9 years total, broken down as 6 years initial confinement and 3 years extended supervision, with eligibility for programming after 3 years of actual initial confinement.
9 years, that's the magic number the state just dropped. And here's why that's interesting. The Department of Corrections recommended something in the same ballpark, but the prosecutor shaved it into a neat 6-3 split. That shows strategy. It looks tough enough for public safety, but measured enough to not seem vindictive. Remember, judges love balance.
When looking at the offense and the read-in charges, it indicates that this is not a case of simple possession, but rather an indication of individual that maintained a drug trafficking place. The quantities of the drugs, namely the 34.3 grams of methamphetamine and paraphernalia gathered, further reinforce that fact. The goals of this sentence should center on rehabilitation and deterrence. When looking at Mr. Langer's history, it paints a clear picture as to why the sentence cannot be probation. Mr. Langer was sentenced in Minnesota in 2015 for possession of narcotics. As a result, he spent the following 9 years on probation. During that time, he repeatedly violated conditions of probation by continuously testing positive for meth, failing to report for probation, and on numerous occasions, attempting to falsify drug tests. Despite various stints in jail and admissions to various inpatient treatment centers, during that time, Mr. Langer continued to use methamphetamines. Since all these events occurred while Mr. Langer was on probation, the next consideration must be jail. In this case, jail would also not be an appropriate answer for the gravity of the offense that Mr. Langer committed. Jail cannot be the solution when such a large amount of methamphetamine is being sold less than 250 feet away from a youth center. Any jail sentence would work against the idea of generally deterring drug dealing. We must then look to incapacitation. As detailed in the PSI, Mr. Langer not only refuses to accept responsibility for his actions, but he rationalizes those actions to minimize the seriousness of the offense, that he was only selling methamphetamines to support his personal habit. This is more than just sustaining a personal drug habit, but rather a repeated history of engaging in dangerous behavior. For instance, on page 11 of the PSI report, Mr. Langer recounted his version of events as they relate to the charges he received in May of 2007 for terroristic threats, aiding and abetting manufacturing of methamphetamine, and causing or permitting a child or vulnerable adult to ingest, inhale, or be exposed to meth. In that section of the report, Mr. Langer explained that there was a dude coming to his garage and making methamphetamine. His girlfriend at the time had a child that had access to that garage, but he claims that she only turned him into law enforcement because she thought he was cheating on her. According to Mr. Langer, he was leaving the building and his then girlfriend was screaming at him from the third-story window of said building. And Mr. Langer, in response, told her he was going to slit her throat and pull out her tongue so she could not report him to the police. This has certainly cause for great concern. Mr. Langer is willing to resort to such violence.
Whoa, that escalated fast. Did you hear that? Threatening to slit someone's throat to cover up meth manufacturing. This isn't just addiction, it's intimidation and violence tied to drug activity. Prosecutors live for these details because they shift the narrative from struggling addict to dangerous offender. And jurors, or in this case, judges, never forget threats like that
so quickly to protect criminal activity. In this instance, the manufacture of methamphetamine. The PSI also describes Mr. Langer's long history of drug abuse. While he was previously on probation, Mr. Langer simply could not follow the directions of his probation agent, nor the conditions of his probation generally. To his credit, Mr. Langer went to inpatient treatment. He did weekly meetings with the DOC agent. However, he still continued to test positive for meth use and failed to report once again on numerous occasions. As such, he needs treatment in a confined setting. Given Mr. Langer's current jail credit, the court should structure this sentence in a manner that ensures that Mr. Langer actually sits in prison for a moderate amount of time before actually becoming eligible for any programming. Since he does not have any prior drug dealing convictions, I'm recommending a sentence close to the range provided by the PSI writer. I do not believe the max sentence here is appropriate, seeing how Mr. Langer does not have a past conviction for drug dealing. The max sentence should be reserved for those individuals. Ultimately, this defendant should have a prison sentence of 9 years total, comprised of 6 years of initial confinement, followed by 3 years of extended supervision. A moderate prison sentence can serve as future deterrence for Mr. Langer's criminal thinking. His refusal to accept responsibility and minimize the seriousness of this offense further justifies the structure of that sentence. The need for real-time prison, enough time to reflect before being provided the opportunity to actually conduct any programming to help attack his substance abuse issue. Thank you.
Thank you. Mr. Chapman, argument and sentencing recommendation, please.
Well, Judge, I'm glad the state and I generally agree that the recommendation from the department appeared to be a bit out of scale from what we normally see for possession with intent to deliver of 10 to 50 grams. I believe that a prison sentence for that offense is usually in the range of 4 to 6 years, and the state's recommendation is essentially at the high end of what I've seen in the past for that sort of thing. I don't know exactly why the agent was calling for such a lengthy prison sentence in this case. I suspect it had to do with frustration over how Mr. Langer has done on supervision in the past, but that's an argument against probation, not really an argument for a longer prison sentence. And to be honest, I don't have a lot of experience with the youth center aspect of this case, but I would point out that the youth center in question was not actually involved in any of Mr. Langer's behavior. It's just a geographic fact of where his house is. He wasn't dealing to patrons of the youth center. He wasn't, people from his house weren't using on the grounds and leaving drug paraphernalia on the youth center. There was really nothing connecting it except the fact that his house happens to be within a range of it. So the case involved possession of 43 grams of methamphetamine, and leading up to the warrant, there were 2 sales to the same undercover buyer. Mr. Langer has been to prison in the past. He does have a lengthy criminal history, although most of that started in 2007. I think a lot of his convictions listed in the PSI are driving offenses. And his probation has not gone well in the past. But I would point out that most of the problems listed in the PSI with probation in the past all come from that period during COVID-19, where I don't think Minnesota supervision was even having much of a conversation with Mr. Langer, much less actually supervising him. Call the court's attention to the couple of instances where the agent details trying to have a hold placed and jails saying, well, we're not going to take him right now. It's kind of hard to kick meth in general, but when there are literally no consequences for you continuing to use, I'm sorry, but the probation was ineffective during that period of time. There is reason to believe that probation could be more effective now, especially considering Mr. Langer is asking the court to consider drug court as an option. He has already spoken to Ms. Anderson. He's done the application. She gave me an email that I've submitted to the court and shown the district attorney, which shows that I believe he would be a good candidate for drug court if the court would consider it. I'd ask the court to consider imposing and staying a substantial prison sentence, such as the 6 years the state is asking for, and can use some length of conditional jail time. Despite sentence credit, the court still has up to a year available, although I would think holding some as a penalty for drug court might be appropriate.
Now this is fascinating. The defense pivots. Instead of fighting the facts, they're pitching drug court. That's basically saying, look, lock him up if you must, but at least give him a path out through treatment. Smart move, maybe, but with this record, especially the youth center angle, the question is, will the judge see him as salvageable or too much of a risk?
And supervise Mr. Langer here in Burnett County and actually monitor the areas of concern that I think were allowed to skate on previous areas of supervision. I think that there are mental health concerns here. I'd note Mr. Langer in the PSI suffers from anxiety, depression, bipolar disorder, PTSD, and ADHD. He's been using methamphetamine for a very long time and was exposed to older people who were manufacturing methamphetamine when he was still a young teenager. It's a difficult drug to stop using, and Mr. Langer has been using it for a very long time. He does, to his credit, actually maintain employment, and although the agent uses that as a mark against him because he should have money, why is he still selling? I don't believe that that necessarily means you can support a substantial methamphetamine habit just because he happens to have a job. And that doesn't mean that he was not a user. The agent seems to imply that because he was employed, he must simply be selling for cash. And I don't think the evidence supports that. Mr. Langer clearly has a long-standing addiction. And for what it's worth, I think he was being completely honest with the PSI author that he does need that extra income in order to actually maintain his own habit. He's not out getting rich selling methamphetamine. You can tell that by his lifestyle. I do think the fact that he's consistently employed shows that he does have the ambition to actually want to live a normal life. And it's going to take more of an effort that he's put forward in the past. However, I do believe that treatment court can maintain accountability in a level that hasn't been tried before. And there is a possibility that Mr. Langer will be able to live a law-abiding lifestyle without having to send him to prison at this time. That's all, Judge.
All right, thank you. Mr. Langer, I'm now, well, did you give me an amount of your recommendation?
I didn't put a specific number on the probation, Judge, but I did suggest that imposing and staying the sentence that the state requested.
Oh. All right, Mr. Langer, I'm now going to give you an opportunity to make any statement you wish to the court. You don't have to, but it's your only time to let me know if you've heard anything that you may want to elaborate on, or you want to correct, or anything that you want me to know and to consider before I sentence you, okay?
The only thing I'd like to say is that I do take full accountability for what I did, and I would like to apologize to the community and to my family, to everybody involved for my actions. I know they were wrong, and I'm truly sorry for it. I really just am very sorry for my actions. I believe that the short-term treatments just were, not, I learned very many skills, but it was just a dry out period. 30-day program is just, it didn't, I'm not blaming the treatment centers, but it just didn't help me very much. But I would very much like to try drug court. I believe it would hold me accountable. I've heard good and bad things about the program, but I have 100% faith in myself that I could, with that help, stay sober and give back to the community.
All right, thank you. Mr. Langer, you've been in front of the court before, you've been in front of this court, you've been in front of other courts, so you know what the courts need to look at with regards to sentencing, but I'm required to go over that with you again. In sentencing, a judge has to look at certain factors and certain things. The first is the nature and gravity of the offense. How serious is this crime? How serious are your actions and your conduct? Then I have to look at your character. That includes your criminal history. It includes all of the information that's contained in this packet right here, okay? Which I have reviewed. This pre-sentence investigation report I have reviewed at least twice, and I've made my notations from what I've reviewed and what I can see. The third thing is I have to look at needing to protect the public, all right? And that means either if there are specific victims or the community as a whole. Other factors that I need to look at are if you have any rehabilitative needs, if you have the ability to rehabilitate, if you have any undesirable behavior patterns. If I can look at your history and say, okay, he has a pattern here, it's really undesirable. Your culpability, your age, your education, And I also have to look at deterrence. I have to look at specific deterrence and general deterrence. Specific deterrence is I need to look at this matter and come up with a sentence that should deter you from committing similar crimes or crimes of this nature. Okay? I also have to look at general deterrence, that is deterring others from engaging in this type of criminal conduct and doing what you did. Okay? Here, I have listened to the arguments of both counsel and I've heard your statement. And I've reviewed this pre-sentence investigation report. You have admitted to a very serious crime. It's more than just possession of methamphetamine. This is possession with intent. That means you had the intent to deliver, to sell, to engage in that type of conduct with others or to others. You made that conscious choice to engage in this conduct. You also were facing, in this case, other very serious allegations and charges. Another manufacturing and delivering of amphetamine, methamphetamine, less than 3 grams near a youth center. Another charge of manufacturing, delivering amphetamine, methamphetamine under 3 grams with the modifier of near a youth center, maintaining a drug trafficking place, and possession of narcotic drugs. That one was as a party to a crime, but party to a crime means you engaged in that crime in some way, shape, or form. During the plea, the court went over its colloquy with you and dismissed and read ins, and your attorney went over that with you in the fact that the court can look at those charges when determining a sentence, okay? You can't be sentenced more than the maximum possible penalty for the crime you pled guilty to, but the other crimes can come into play. Those other charges can. Now, when we look at this case and we look at what you were originally charged with, and if the court calculates this, I come up with 57 years of prison hanging over your head. If you went to a jury and the jury found you guilty of each of these charges, 57 years of prison. Most of it in